Ladies and gentlemen, welcome in here to a Thursday night murder church. Thought I would do, I didn't know what I was going to be doing tonight originally. Thought maybe a Phil Spector, but now I'm going to go over some of this Bryan Kohberger stuff that's happening right now as we inch closer to the Idaho 4 Bryan Kohberger death penalty trial. That's out of Idaho, Moscow, Idaho. So yeah, we got Bryan Kohberger on deck tonight. I got this article here from Fox we're going to be looking at, and then we're actually going to be watching, I don't know, probably an hour or so of the hearing from yesterday. That's extremely long. There's no way we'd get through 8 hours, but thanks everyone for coming in. Hit the old like ski and yeah, give it a share on X.
Let's rock.
Hello, you beautiful people. Welcome in here. Boom. We made it on a Thursday night. First Thursday in a couple of weeks. So I've taken the last couple off. Hold on. Let me turn this light on. Boom. Makes it pop just slightly back there. What's up? What's going on, everybody? Hope everyone's having a good week. We're working our way through this week. Almost got ourselves a Friday. Ready to rock and roll. Excited about that. I'm going to be, of course, going into Feral Friday. I've got a very special guest that's coming through on Feral Friday this week. This week we're going to have none other than Jessica for Justice joining me tomorrow. And we're still talking right now. We're still working out a film that we're going to be watching. But I know Jessica is a big horror fan. And of course you guys know that I am as well. So yeah, probably going to be more on the actual horror, legit scary side. So just a heads up on that. But tonight also, just as fucking scary, Bryan Kohberger. Probably gonna get some heat from some folks for saying that, but yeah, it's the walls are closing in on Bryan Kohberger. It seems pretty effectively. Judge Hippler has been laying down the law. He's been very fair, very even, in my opinion, in everything that I've seen thus far, whether that's from the defense or from the prosecution. He's also told the prosecution how it goes from time to time as this goes on. So everyone in here right now, let's see if this is working. Hold on. If we can get our fine folks in here to chat. Let me also hit the bells. Did that work? Hold on. Okay. Hold on. There we go. Yay, Jessica. That's right. Got Jessica coming in here. No, let me get the bells. Hold on. Hold on. Don't rush me. Don't rush me. There we go. Starting them sons of bitches out right, baby. That's right. Boom. Smash that thing if you come in here right now. Smash her up. Boom. Boom. Smash that hoe. You know what I'm talking about. It's been so long since I could attend. Dixie, welcome the hell back in here. Get in here. She's in the pews tonight hanging out. I love it. I love it. Love to see it. Hell yeah. Again, like I said, tomorrow night, we're going to be probably watching a legit horror film. I don't know exactly what, but it's going to be, I don't know. The one we're kind of talking about right now is a possession film. And the trailer looks pretty cool. But I also do have one thing in mind, and I don't know if, I kind of tossed it out there, and I'm not sure if Jessica, she wanted to watch it, but I don't know if she's feeling it for tomorrow. Before I'm doing the Charles Manson, the Manson family, the 60s-esh stuff, really it's mostly in the Manson family yet. I haven't really dove outside of that quite yet. But there's a movie called The Manson Family. It was made from like the mid-90s. It was made from like 97 to 2003. I think it was originally released in 2003. It's a lower budget film, but it is the craziest depiction of these murders, and it also blends in its own story that we're definitely going to be watching very soon on Feral Friday. And once upon a time, welcome in here, next chapter. Brooklyn, thank you for modding tonight. Appreciate it. Pammy's in the house. Carrie's in the house. Holly Berry's in the house. Once upon a time, I almost showed it with Dan, and, still could possibly watch it with Dan. But when I told him basically some of the scenes and what was going on, this was back when we were kind of being a little bit more conservative with some of the stuff we would show. Really just because this is true crime at the end of the day. But, as this is really, truly went on, this is exactly what I want it to be. I'm not afraid to really show anything at this point, because if you're hanging out, if you understand my personality, my sense of humor, you're going to be good. I know not all things that I show probably on Fridays are for everybody. I get that as well. But yeah, I think it's going to be very, very interesting, and probably get some wild reactions as well. Before we go any further, who is keeping up with this Bryan Kohberger madness that is currently unfolding every day on X, because people are losing their fucking minds. They can't handle life. Let me get in here. Hold on. What went Bryan Kohberger's way and what didn't at evidence motions hearing? Bryan Kohberger's defense struggled with prosecutors over what evidence should and shouldn't be allowed in his upcoming quadruple murder trial at a full-day hearing in front of Judge Stephen Hippler of Boise, Idaho on Wednesday. Dude, Hippler is awesome. If anybody hasn't watched any of these hearings yet, a real contender for one of my favorite judges. And we all know I love Judge Die Hard. He's my man. Fiddler is the best, Larry Fiddler. But hey, man, Hippler is. I'm enjoying him quite a bit. Kohberger 30. Of course, the people that are hardcore on Kohberger's side, not me. I'm way more in the middle. I'm actually way more leaning towards he is probably guilty at this point in time, honestly. Still want to see the trial. Still want to see everything laid out. Still want to see all of these terabytes of surveillance that's going to be pinpointing Bryan Kohberger in a car in this vicinity. I still want to see all those things, all of the circumstantial stuff that is going to be pointing the finger at Bryan Kohberger in court laid out. Don't get me wrong, but let's just be honest here. Kohberger 30 faces 4 charges of first-degree murder in the deaths of Madison Mogen, Kaylee Consalves, Zainer Kronodal, and Ethan Chapin. He also faces a felony burglary count. Hippler decided some motions from the bench, but said he would announce other orders later in writing, including his findings. And I love the way he kind of handles business. We've talked about this on here with Bob in the past before when we've talked a little bit of Kohberger and Hippler specifically, but and Bob says he handles it like an appellate court, and he's kind of going back and forth in real time with whoever's up there kind of arguing their points, whether it's from the prosecution side or from the defense side. It's a very interesting way to handle the courtroom, I think. And again, like I said, in my opinion, fair. Hippler decided some motions from the bench, but said others would be, later in writing, including his findings on defense motions to strike the death penalty. So basically, the defense wants everything off the table, any and everything. And even one of the quotes in here is that they're not throwing spaghetti against the wall to see what will stick. They want the death penalty off as a potential punishment due to Kohberger's diagnosis of autism and defense's claims that the prosecutors have missed key discovery deadlines, which when this was brought up during this, I don't know if we'll get to this in this hour or however long we watch this, when that was actually brought up by Hippler, he brings it up straight up to Ann Taylor right in her face. And he says, these are some pretty strong accusations that you're saying here that the prosecution hasn't done their due diligence in giving discovery. And she couldn't even refute it in that moment. It is absolute bullshit. Defense attorney Ann Taylor said the recent Lori Vallow case in which the court threw out the death penalty over missed deadlines. Kohberger, however, has waived his right to a speedy trial. And Hippler asked Taylor why she hasn't raised the issue months ago or requested more resources, like a half dozen additional paralegals to help her go through the discovery. And her whole issue is how much is to go through. It's going to be the surveillance stuff. It's going to be hours and hours of surveillance that has nothing to do with the moments in question. I think it's mentioned here. Deputy Latah County Prosecutor Ashley Jennings also flat out denied Taylor's accusations that prosecutors were slow walking discovery and said everything the defense asked for has been provided, a point that Taylor conceded in front of the judge. Right there. She had to concede that after making stink after stink about not getting this discovery, not getting stuff in a timely fashion. This quote right here from Bill Thompson. It's all incriminating evidence. That's why the state is offering it. Right here. Kohberger seeks to strike Amazon click and purchase history. Gee, I wonder why. Cell tower and Kohberger phone data that is not going to be able to be explained because he turned his fucking phone off before the commission of the crimes and then turned it back on after the commissions of the crimes. Touch DNA testimony. They're going to argue this should be called something else. This was illegal the way they got the DNA and it led to Bryan Kohberger. The 911 call, they think that should be thrown out. I think that they're agreeing to a transcript. I think the prosecutors are also agreeing to a transcript that they're going to allow in. Police time run video and all surveillance video near crime scene. They want all of that thrown out. Gee, huh? This motion is not about withheld discovery, she said. It was instead about a vast amount of data, dozens of terabytes, that she said will take years to go through. Hippler told her he expects most of it is irrelevant surveillance footage that doesn't need to be gone through. But he said he would likely require the prosecution to clarify that it was disclosed all potentially exculpatory evidence that it is aware of and that the defense has not already flagged. He said he would issue a written order later, after arguments over Kohberger's alibi, which prosecutors said cannot be corroborated by anyone other than the defendant himself. Remember, he's just, after weeks of this, we've got an alibi, it's coming. It ended up being stargazing. He was driving around by himself, no actual alibi except for his own, me, myself, and I. The judge on both sides appeared to agree that defense expert of Psi Ray could testify about Kohberger's whereabouts at the time of his phone. Hold on, fuck. Okay, hold on. Thought I fucked up the mic there for a second. The judge on both sides appeared to agree that defense expert Psi Ray could testify about Kohberger's whereabouts at the time his phone was shut off, more than an hour before the murders, but Latah County prosecuting attorney Bill Thompson made it clear that that is not an alibi. Who was going to say he was out driving, looking around at the stars? And this is Hippler to Taylor. She said her client has a right to remain silent. The question is whether you have a witness who is going to testify to that, Hippler said. Hippler partially agreed to a defense motion to block prosecutors from using words murderer, psychopath, and sociopath in the trial, but noted that what the defense had asked for amounted to issues in an order that says the state shall not commit prosecutorial misconduct. He said he expected the rules to be followed, that the term murderer could potentially be used during closing arguments, and that the word psycho and sociopath could not be used unless an expert evaluation determined. I love this ruling right here. Unless an expert evaluation determined that accurately applied to Kohberger, something that has not been happened as of Thursday. They should do those tests, right? As for inflammatory evidence that the defense wants kept out of trial, like overuse of gruesome crime scene photos, Hippler said the murders were brutal and horrific, and he expected evidence to reflect that. In one key moment, Taylor claimed that the defense had uncovered a new lead regarding a potential alternate suspect and was investigating. In another, she said there are 100 hours of interviews with people who knew Kohberger from Washington State University, and many of them had unkind things to say about him. Kohberger was studying for a PhD in criminology there. The campus is about 10 miles from the University of Idaho crime scene. Prosecutors revealed that they do not expect any of the inconclusive DNA samples under Mogen's fingernails to belong to Kohberger. Because they believe the attacker wore clothes to significantly cover himself up, the defense sought unsuccessfully to have a 2020 college essay Kohberger wrote about crime scene handling for DeSales University, where he studied for a master's degree in criminal justice, excluded from the trial. So yeah, this came out a couple of weeks back, maybe even before that. Him basically telling exactly how to clean up a crime scene. You know, being in that field, it already made sense for him to write a paper like that. That's not the weird part. You know, it is someone in this, potential line of work ending up committing these murders and then knowing kind of what to do, and then a big fuck up happens. And that's exactly what we're kind of looking at here. Judge Hippler also took issue with the defense expert witness who he said accused prosecutors of severe misconduct involving discovery materials regarding Kohberger's phone tracking records without evidence. I don't want theatrics, he told Kohberger's defense. This got a little spicy just kind of reading it. I didn't watch this yet. This was reading through, there was a Fox News guy that was there live, I'm assuming, but doing a live tweet by tweet or post by post on X, and it was pretty interesting. And this part seemed very spicy. It says, I don't want accusations that aren't supported. At issue are timing advanced records, detailed location data from a phone that is only preserved for 7 days. Now, this was interesting because everyone says, he's got this. It's saying, so I'm going to just read it. At the prosecution's initial search warrant sought this information in November. Kohberger wasn't identified as a suspect until November 19th. Jennings said she did not have the records. Hippler asked Taylor what evidence she had that they even exist. So, these are only preserved for 7 days. So if that's in November and then they don't actually find out who the suspect is, Bryan Kohberger, until December 19th, those are gone, is how I understood that. The hearing touched on other issues such as whether Bryan Kohberger's immediate family has a right to courtroom seating. We also learned that probably more than one member of Kohberger's family is going to be called up on the stand, and I would imagine that's going to be the sister and probably the dad. Prosecutors noted that some relatives will be on the witness list and as such shouldn't be allowed to observe testimony in a case prior to taking the stand themselves. A lot of people that are more on the defense side are kind of taking that as a slight and saying, they're trying to block Kohberger from having anybody there that's on his side, and the prosecution made a fair point, I thought. While Kohberger's defense attorney, Elisa Massoth, said the family had no interest in helping, the prosecution and predicted that prosecutors will only call one relative at best. So, they're saying possibly one, Jennings revealed the prosecutors intend to call a few. So yeah, excuse me. I was reading that completely weird. Not one at best. They may be calling a few, which again, going back to what I think Michael Ruse is who I was following when he was just doing a really good job of doing a tweet storm on this. The defense wanted the 911 audio blocked from being played before the jury. Hippler said he would likely allow it, but redacted some statements that could be considered hearsay. Similarly, he said he would consider redacting portions of a traffic stop in which Kohberger had a back and forth with the officer in the months before the murders. We've seen that online. Prosecutors said they intended to use it to show his ownership of the white Elantra. Right here you can see a picture of him. We're about to see this right now. I made a tweet about this lady earlier. This has got to be one of these wacko accounts on X, guys. It's got to be. Massoth took issue with referring to Kohberger's car as a suspect vehicle, and I think this does make sense. You don't get to, and I don't get to, tell the state how to try their case unless they're violating the rules of evidence, says Hippler. Hippler appeared unsympathetic to the defense's opposition to include Kohberger's Amazon records, which show the purchase of a K-bar knife and sheath set before the murders, as well as searching the app for the same items after the murders. So this is huge. All right. This is something that was basically being talked about and said even by people before this came out. If it shows that he was buying the knife, oh shit, I may change my tune. Those people did not change their tune. Those people have not changed their tune at all. He bought the knife. They're going to show with Amazon him purchasing a K-bar knife and a sheath. And after it was all said and done, after he left the sheath, the murders are over. I'm assuming, probably using some kind of joint account with family. This is also where family can come in, trying to rebuy these items. Okay? Maybe I'm completely out to lunch, but as I understand it, to buy something on Amazon, you got to put it in your shopping cart and hit purchase, the judge said. Hippler said he would take a defense motion to block surviving roommate DM. Like those, like this right here from Hippler. I love that, dude. That's exactly, and he does that to the prosecution as well. But the defense is really pulling some bullshit tactics in here, I do believe. Hippler said he would take a defense motion to block surviving roommate Dylan Mortensen from using the phrase bushy eyebrows during her testimony. Taylor also revealed that in addition to DM's text messages and phone history that were released last month, the roommate's phone data shows she was also editing photos, saving new contacts using social media, and a whole lot more. Hippler said that while other older adults may pick up the phone and call someone, younger people are just as likely to reach out over social media. I'll be interested to hear the testimony of the two ladies. That is going to be huge. All right. The fact that they don't want that to be heard. I mean, they don't want anything to be heard, quite frankly, from this case. He said, referring to DM and the other surviving roommate included in court documents as Bethany Funk, as we know her, but they're calling her BF. We've been saying her name for long enough for the last few years. No reason to stop now. Kohberger could face the death penalty if convicted unless Hippler rules in his favor on one of the motions to strike. A judge entered not guilty pleas on his behalf on May of 23. So we're going to jump in here. We're going to watch a little bit of this. Again, we're going to watch from the beginning. We're not going to get through all of that, I'm sure. But there's a lot of interesting stuff going on in Idaho right now. And a lot of opinions out there from a lot of different folks. I would get into it pretty frequently and pretty regularly on X with different types of folks. Some people are nice, some people are kind, some people can have a back and forth in a conversation. I'm also known to get heated on there, absolutely admitted. But I really have tried really hard to have normal conversations on there for a long ass time now, and they do make it hard, I have to admit. But I feel like I've done pretty well with not engaging absolute psychopaths. Every once in a while I do dip my toe into that sphere. But yeah, I mean, I think a lot of people are being, they're following old narratives that were brought out before some of the new evidence and some of the new stuff that we're seeing come out in some of these motions. They're going with some of these other YouTube narratives that's been created out there by folks that I was a part of it, created this stuff out the gate for views and clicks, and that stuff is still very heavily in a lot of folks' heads. And it's not even the majority of folks is what's crazy. All right. Like when this case first started up, this was huge. It was the biggest thing going. Karen Reed dwarfs what it was ever, but it was still pretty big. Everyone was talking about it. Every channel, clickbait all over the fucking place, including from me. I would put that shit out there to try to get inside basically the true crime sphere, and it worked, quite frankly. I have an awesome spot right now, but I backed out of that from basically this case being gross as fuck. And I think a lot of people are still lost inside of bullshit narratives that were created again to create doubt in sadly some individuals' heads that, you know, whether it's lack of critical thinking skills or not being able to change your mind. We see that all the time now. I preach about this basically daily on fucking X. Once people have their mind set on anything outside of true crime, anything, it doesn't matter. It could be breakfast in the morning. It could be anything. If you have somebody that's opposing it, it's going to get nasty, and people stick their heels into the sand and they will not back down, even if I feel they know they're wrong. I've done it a lot as well. I've done it with my own brother on this show, and I'm pretty open about how it sucks and how that's not the way to be. And I'll do it in real time in a conversation on X as well. In a real fucking time, be like, you know what? I'm wrong. That is the true way in growth. And the only way to get growth is through being honest with yourself. So, yeah, let's jump in here and see what the fuck's going on. And, yeah, thanks everyone for being here. I appreciate it. I think we're only 2 names away from a wheel spin. I'll keep my eyes on that as well, folks. And, you know, a great way to get on there. Oh, shit. Fuck. Dixie. We're only 1 name away because Dixie came through the Venmo machine and said, much love to my PB fam, and sent a $20 holler. Dixie, thank you so fucking much. I appreciate that. That is what I'm talking about. I'm going to make sure we're 1 away before I do that. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11. I think we're 1 away, folks, from a spin. Dixie, thank you so much. I appreciate that. Oh my God, it's over right there. I think Pammy just finished that son of a bitch right up. I think she just said, fuck it. She just kicked it right in the ass. She said $10 to the Cash App. Okay, I did see. Okay, I'll also show this real quick before we jump in here, Pammy. Hold on. Let me get your name on here. $10 holler. Thank you so much. We'll get a spin going. Let me put this so I can remember. But I'll put a picture up of me and Dandy Savage, all right? We're children. She says, mutual childhood haircut, different decades in color. So she was rocking this do as well. Let me pull this up here just real quick, folks. Oh, there, Botrix decided to wake up, the son of a bitch. So I'll put a picture of me and Dandy on the old X machine. And yeah, apparently Pammy used to rock this do. It is a bit of a like 70s haircut, honestly. If I'm going to be honest about it, like it's a little shaggy. Look at that shit, right? How the fuck? Come at us! Come at us! We've always been the coolest motherfucking cats in the school. Are you kidding me? Dandy Savage coming through here, killing it. Killing it, son. Boom, out here. Not even playing. Not even playing. Goodness gracious. Pammy, thank you so much. I appreciate the shit out of that. Let me give you a little bit of love. First of all.
Are you crazy? Are you out of your mind?
You're crazy! Loving it. Loving it. Hanging and banging. Hanging and banging. Right, Shelly. Shelly knows. Thank you for coming through here also tonight, doing a little modding, baby. We got Bluebird in here. Yeah, Salty Sleuth's coming through here, hanging out. I appreciate it. Salty. She's all over the Bryan Kohberger stuff. I know she's been streaming pretty regularly and even daily up in here on that, so hell yeah. Pokemon question for the room. If I search K-Bar on my Amazon that my sister is using because of her current life choices, and she ends up on Dateline, am I responsible? You know, that's a damn good question, actually. Damn good question. I don't know why I changed that, but I did. All right, let's get in here, folks. Let's watch a little bit of this. See how the sound's going to be.
Defendants motions in limine regarding inflammatory.
I do hate the way the cameras are. I hate the steady standalone cam. Like, I think the trial's going to suck for that. But
Evidence, use of the term murder, and use of the term psychopath or sociopath.
Thank you, Your Honor. I'm guessing from the court's comments, the court wants me to address all three of those. I'll do that then. Your Honor, the motions
also, I'm going to show this just because I was feeling it today, baby. I made this post that I think about everybody probably in here right now, especially in the nation, really saw this. But I'm going to read it right now just because I'm feeling it, baby. The Buzz Nation fucking rule, and I'm really glad that the real ones are the ones that are the keeping it real around here as well. I used to hesitate to express my true feelings about cases because of the pressure to conform to the team mentality. What do I always talk about on here? I didn't want to upset the majority, fearing they'd turn against me and stop watching my show. That was a huge fear in the beginning. Such a stupid thing. But then I realized that those kinds of people weren't actually watching me anyway. This is one thing that I could give anybody that's just starting out, and if you start to get on exit, this was something I did anyways. You start to get in these like heated discussions, or you start to see people, there's like a tactic also. Some people will be like, I used to watch you, I'm not going to do it anymore, from an opinion, right? Those people did not watch you. I guarantee it. And if they did, they couldn't have watched you. And in my opinion, that's because usually I've been pretty fucking open-minded about stuff, and you would know that opinions are, and this was a recent thing. It wasn't like a past thing. So, but yeah, I mean, you've got to have an open mind, I think, out the gate to be in true crime, to be in the sphere to begin with. I keep an open mind about everything in these cases and don't just blindly follow one popular opinion, which is really seems to be the norm. And again, what am I going back to here? I know we're all over the place tonight, but folks, they get stuck in this fucking idea, and then their buddies also in this idea, all right? Whoever their homie is online, or maybe not even online, maybe in real life, and then they are stuck in it forever. And then there's another person that comes in, and then they start patting each other on the back because, oh, now this is our crew. Oh, somebody's coming after you? Oh, no, we'll gang up on them. It's like this weird gang mentality of fucking weirdness. The folks who tune in and vibe with the Buzz motherfucking Nation, are there because they enjoy me and Dan, not just the case that we're currently going over or whenever, like a Kohberger. I'll take a handful of real supporters over a crowd of fakes any day and every motherfucking day, dude. And I'll stand by that shit until the end. All right? Anybody wants to fight, we can go out in the street. All right? Oh, there's a lot of fucking shitty people, dude. That shit annoys the fuck out of me. But yeah, back to my point there. You'll see people kind of do those posts. You'll get back and I did it as well. You get back and going back and forth, and all of a sudden, you know, oh man, I can't go too much. I can't go too much against the grain here. I'm gonna lose that person. They're not gonna be on my next stream. I'm telling you right now. Anybody that's just watching out there, maybe other content creators, those people weren't watching to begin with, and if they are, maybe they'll do a little hate watching, which is also fine, whatever. But at the end of the day, the real motherfuckers are the ones that are saying, what the hell is up on a daily basis? You're talking to them. You're creating an actual atmosphere with a real community, all right? And that sense of community is felt. Like, you will feel the real ones.
Brought to the court based on Mr. Kohberger's constitutional rights and the rules of evidence and relevant case law. With regard to the inflammatory evidence, that is requesting that the court issue an order preventing the state from trying its case.
4 months, Christine. Oh my God, that's awesome. Thank you so much for your support. Seriously, that's absolutely unbelievable.
Happy anniversary.
Get a happy anniversary in here.
An emotional appeal or an excessive use of emotional phrasing or an excessive use of repetitive photographs. Certainly, we understand that there will be photographs that we may not like that come in, testimony that we may not like that will come in, but what we're talking about is an excessive use of emotional appeal. That the examples that we've seen in relevant case law come from State versus Ellington. In that case, the prosecutor repeatedly used a phrase that was inflammatory about the defendant having run over the wife of a witness who was testifying.
Every morning.
And that was found to be inflammatory because of the excessive use of that phrase. Additionally, in that case, there was an appeal to juror emotion when the state sought testimony from a witness about why he might have left his job. Those are examples of what we're talking
16,
about.
Brooklyn.
The
Still
court
loves to
has to
confuse,
do
baby. Thank
the
you so
rules of
much.
evidence balancing test, and to
incredible.
do
Let's get a
that
will going. How about
after the
that?
state has
get
elicited
this thing.
inflammatory testimony is difficult to undo and puts Mr. Kohberger in a position where the jury's already been inflamed, and so we're seeking to prevent that.
I'm inflamed.
Your Honor, I will move then to our motion regarding the murder term. This motion is also based in Mr. Kohberger's constitutional rights to due process and to a fair trial. This is not a motion to ask the state not to use the term murder. That's going to come out when the court reads to the jury the charging document. That's going to come out in jury instructions. This motion is about the state, through its witnesses,
Jay
labeling
Money.
Mr. Kohberger. That invades the province of the jury. Mr. Kohberger sits here today. He's innocent, and it's up to the state
Damn,
to
that's a
bring
year.
evidence
Shit.
and a jury to decide if that's
Get
different.
that pink, baby.
The state, by using that
Jesus,
kind of
working on
term
2
as
years.
applied
My God, y'all are coming the fuck in right now.
to
Thank you
Mr.
so
Kohberger
much.
gets in the way of what the
Crazy.
jury needs to decide.
Give away
Back
some
when
shit.
we were looking at a change of venue in this case, we
God,
worked
you know they
with a
regret
social
that.
scientist named Dr. Amani El Aleli, and she talked a lot about how bias is made in people and how we think about things and how we remember things. And one of the things she talked about, and her report is in the court record, one of the things she talked about is the influence of people in a position of authority. And for the state to come in and label Mr. Kohberger in their position of authority or ask a witness, especially a witness in uniform, to do so is very detrimental. It's inflammatory to Mr. Kohberger, and it would
Outside of opening statements, perhaps, where the state might say, we intend to prove the defendant murdered the victims, perhaps in reference in voir dire, that, in this case,
Boom.
the defendant is accused of murder.
Got a will.
I'm having a trouble understanding how this would come up during the evidence phase of things.
Holy shit.
Your
Michael
Honor,
coming through with a $5 for the boobs. I mean the will. Oh shit. Damn. You kidding me? Micah knows what the hell's up. You know, we're already doing up in Publicly Buzzed. If anybody didn't see last Phil Friday, man, the boob party, it was out of control. We got a little wild up in here. Micah, you're starting out a new will right here tonight. I appreciate the hell out of that. Thank you all so much for the support. And I've already got another will ready to rock, baby. Holy crap. Coming through strong. Stout. My stout folks. The stout nation.
that's why I'm asking the court to
Dude, you know she
issue an
does.
order to prevent it from coming up.
Sounds like you're asking me to issue an
Yeah,
order.
they want to get away from old Judge, and I bet that they don't want that now. I mean, Hippler is on it, dude. Like, Hippler is on it.
Says the state shall not commit prosecutorial misconduct, or the parties will follow the rules of evidence.
Your Honor, I would like an order that the parties will follow the rules of
I'm
evidence.
sure the state would like one too.
I'm not going to oppose that, Your Honor.
Motherfucking burn, bitch. That was a burn. He's got little slight burns. Look at his little face. He already knows he just burnt that bitch, too. Does he not? Does he not know that he just caught her pants on fire a little bit there? Right? Oh, I bet the state would also like the bullshit to stop.
Get to the state's motion.
I don't think I need an order because, as the name implies, they are rules, which means they will be followed.
Oh, nice, Christine. Yeah. Shit, Christine's Courtroom. Yeah, give it a follow.
Your Honor, in an abundance of
Pokemon, if you
caution, we
find it,
bring these
post it in
motions,
here.
and that's based on review of case law and based on years of experience when things happen in trial. I found and I believe that it's relevant to bring these kinds of motions before the court now and have all of the parties aware of.
I think there's maybe a difference between bringing them to make sure that the issues are highlighted and the parties are vigilant versus perhaps entering sort of prescriptive orders that are so broad and vague in nature that they are essentially meaningless.
Your Honor, this is my opportunity and the place that is reserved for the defense to bring these motions. I think that they're important motions, and with court's orders, it makes it more clear. Even if the court order isn't spelling out, you can't say this, you can't do that. I think there's an awareness, and I think it's relevant to have that order. I think it's important to have that order. And most of all, I think it's protective of Mr. Kohberger's constitutional rights to have that order. That's our request with regard to.
Address sociopath or psychopath? Doesn't
Yes,
seem
I'd like
the
to
state
address.
was intending to go there, but you're welcome to address it.
Your Honor, if the state is stipulating not to use those terms, I don't need to make a full argument on that, but I'm prepared to do so. I'll be brief. Then with that, we brought this motion again.
And as we go through this, if anybody wants me to keep randomly playing this maybe for some lives, I will. And like I said, it's 8 hours.
Under Mr. Kohberger's constitutional rights to a fair trial and
Tomorrow
due
night, right
process
there,
of law.
Jessica for Justice is coming through. We're going to be watching probably an actual horror movie tomorrow night. And the one that we're kind of talking about is a possession film that looks pretty scary.
This motion is really spelled out in Dr. John Eden's affidavit when he talks about the unreliability of tests that might label somebody in that particular way and the danger of having that label applied to somebody. If that's allowed to happen, then Mr. Kohberger is colored with an opinion or a way the jury will view him that is unfair. And our request is that the court not allow the state to label him in testimony as a psychopath or a sociopath.
Joe Schmo coming through the door. Joe coming through, what he's doing. Joe's got a channel, make sure you're following. Joe Schmo. He's right now, he's covering Lori Vallow. He's boots on the ground in Lori Vallow also. So make sure you're following Joe Schmo. One of the good ones out here. I tweeted today. I said he's one of my favorite dudes out here because he's a real of the motherfucking real.
Because any kind of testing is unreliable.
Hey, Joe.
That would relate to, that would become problematic within the rules of evidence to do so. And the inflammatory nature of those kinds of labels would.
I'm not aware of any testing that has been done that has reached that conclusion. Am I missing something?
You are not missing anything. There has not been any testing. There has not been any labeling. This, again, is my opportunity to bring a preventative motion to protect Mr. Kohberger's constitutional rights. And that's the purpose of that motion. Thank you.
Look at Bill. Santa's about to get up.
Thompson?
Thank you, Your Honor. And as the court is aware from the responses that we filed, Mr. Nye and I actually.
Santa's bringing Bryan Kohberger a firing squad for Christmas.
Kind of divide these motions up. We didn't realize they would be heard together. But as to the inflammatory evidence, what the court has noted is exactly what our concerns are. In the defendant's filings, he doesn't specify what inflammatory evidence he's concerned about.
Jay Money, bro. What's going on, man? Jay Money is one of the original first winners of a will here at Publicly Buzzed. And he just now sent me a little cash. He sent me a $3 holler, dude. Jay, first of all, thank you very much. Appreciate that. Got on the wheel. Got you on the wheel.
Hold up! Hold up!
Dude, I am ready for WrestleMania. I've actually been working on a video that's kind of WrestleMania oriented. It's a story that goes around WrestleMania 17 time, and I should be dropping that probably this Sunday. I was actually working on that. It's pretty much done. I may have to do just a little bit of work on Saturday, but yeah, man, I'm excited. I'm ready for WrestleMania. Thanks for coming in here, Jay. I appreciate it.
Only inflammatory, nor are we aware of any definition of that. The words just seem to be used loosely and freely here. And in fact, in the defendant's reply, he acknowledges at page 2 that he really doesn't even know what he's trying to object to. He's asking the court to presume that something's going to happen or anticipate something without a basis for it. We don't see any basis for the court to enter an order. We intend to conduct our trial professionally, and we anticipate that if there are questions about anything that we do, that there will be a timely objection and the court can address it in that fashion. So our prayer to the court is the court deny the request for order.
Hey, Carla, you are on the new wheel that I'm about to spin here very shortly. So you have a very good chance of winning a tattoo, a publicly buzzed tattoo, some stickers, and a magnet, a Murder Church magnet. So stick around. Thanks for coming in here.
That the defendant has made, and simply preserve the defendant's opportunity to object if something of concern comes up in the future.
Your Honor, just briefly, the purpose of using exceptionally inflammatory is used in conjunction with our recognition that in case law, photographs that we might not like will come into evidence. Exceptionally is to define what we mean. And we mean when it's over the top, when it's unnecessary, when it's going to inflame the passions of the jury, and that tips the scale
I told him Santa was bringing the firing squad for old Brad for Christmas.
of relevance. We don't know exactly how the state's going to try its case. We do know there are over 13,000 photographs, hundreds of hours of videotape, and many, many witnesses who the state will call to testify. We believe that it is imperative that we have an order to prevent the case being tried in a way that presents inflammatory evidence and appeals to emotions for the jury.
These cameras suck.
All right, the standard for motions in limine, which I'm about to set forth, applies to most motions today that we will address today, and I don't intend to repeat this with each motion, but for the record, let me go through it once. Evidence is relevant if it has any tendency to make the existence of any fact that is of consequence to the determination of an action more probable or less probable than it would be without the evidence. All evidence, all relevant evidence is admissible except as otherwise provided by the rules of evidence or other applicable laws of the court or of the state. Although relevant evidence may be excluded if its probative value is substantially outweighed by the danger of unfair prejudice, confusion of the issues, misleading of the jury, or by considerations of undue delay, waste of time, or needless presentation of cumulative evidence. The question of whether evidence is relevant is a question of law to be reviewed de novo, while the decision to admit relevant evidence is reviewed for an abuse of discretion. On discretionary matters, the trial court must correctly perceive the issue as one of discretion, act within the outer boundaries of its discretion, act consistently with the legal standards applicable to the specific choices available to it, and reach its decision by the exercise of reason. So my concern with the motions is not the substance of them in the sense that I think it's appropriate to highlight those issues that everybody should be cognizant of. It's in fashioning an order that has any real meaning because of the breadth and lack of specificity.
That's a wild theory, Gary. I hadn't thought about that.
The motions. With respect to the use of terms psychopath or sociopath, I do understand that there is no evidence that the defendant specifically has been tested and found to be with that diagnosis or personality disorder, if you will. And I understand the state is not intending to, at this point, seek to attach that label. Absent evidence, competent forensic evidence, if you will, qualified expert evidence, and I haven't worked all the way through penalty phase, and I suppose that could come up in penalty phase of things, but for now, certainly for the guilt phase, innocence phase of the trial, I am ordering that the state and its witnesses not use those two terms where they're equivalents. If something happens where you believe a door has been opened before launching into that in front of the jury, you are also required to bring that to my attention outside the presence of the jury. With respect to the term murder, well, let me start with the term murder.
Before you do that, Judge Hippler, Carla, she's like, you know what? I may be on this will, and I may win, but you know what? I'd like another chance on the next will. Thank you very much. And by doing that, she gifted out a membership, which, let me do a little plug ski here. Oh my God, the new member, the person that just got membered up. Also, when we get new members, beers in the chat, hell yes in the chat, effing oaths in the chat. C. Taylor, welcome in here first and foremost. Welcome to the party. Let me give you a little love. Hold on.
Welcome to the party, pal.
Appreciate the hell out of that. You are also now in the Buzz Nation Book Club every Tuesday night after Murder Church. We go right into book club. It's a members only thing though, but you have the opportunity to get in here. Currently, we're reading The Stranger Beside Me, an Ann Taylor book, a Ted Bundy book. It's very interesting. We just got through chapter 9. We're going into chapter 10. We're about a quarter of the way through the book now, but all of the past episodes have the past episodes are extremely detailed because I take very detailed notes as I go through these chapters. And then on Tuesday nights, I read through them. We go through with the chat. We do a little conversation. Hell yeah. If you're not in the Buzz Nation Book Club, well, then you're done fucked up. You've already fucked up. I hate to be the bearer of bad news, but that is the truth. You fucked up. But Carla, it has not fucked up because she's in that son of a bitch, and I appreciate the hell out of that, baby. No, screw it. Oh, we got to pause real quick because I'm feeling it tonight, baby. Woo! We're going to give away some stuff, huh? We're going to give away the tattoos, the publicly buzzed tats. Put that on your skin. The publicly buzzed magnets. The publicly buzzed stickers. Huh? Got multiple stickers. We're going. Good luck, everybody. And that's Pammy. Pammy! Yes, Pammy just now picked up some tats, baby. Pammy's a winner around these parts, baby. Let's go! Let's fucking go. That's what we said.
I'm sober enough to know what I'm doing, and I'm drunk enough to really enjoy doing it.
Let me get you in the winner circle here, Pammy, so I do not forget. And I think next week I'm going to start getting some new stuff out. I got some shirts to get out. Of course, some new trinkets, some more goodies. Always headed out the door. Let me see. I'm going to put tat, stickers, and maggot. Boom. And we, of course, have already got another wheel already building. So, you already know how to do this stuff. You guys are set, baby. Well, let me just get this here. Boom. Going back in for Hippler here. Thank you all so much. Love it. Got the best people up in here. That's all I know. That's all I know. That's all that's for sure. The best motherfuckers hanging out, baby.
So obviously the jury is going to be charged with what the charge is or our charges are in this case, which
so much.
Include first-degree murder. I don't think there's any problem in using the term murder as it describes the charges and the allegations. Testimony or statements by counsel or by others that the defendant is a murderer or committed murder, I think would be essentially argumentative in nature at this point. I will tell you that the one thing that will get my dander up quickly is either counsel attempting to argue outside the one opportunity they have to argue in a case like this, which is closing. And I will shut you down faster than you can imagine if I see that. And if I see it again, I will admonish you in front of the jury about it because I'm serious about not arguing.
It's going to be a clean record. I almost guarantee you there's not going to be very much fooling around. You can feel the energy off Judge Hippler. He does not fuck around. He does not mess around. He is not going to be one to play with or mess with when this is actually going. And for Bryan Kohberger's own good, let's hope that that's how it stays from the defense. But also for people that are on the opposite side from the state, you would want to also hope to God that they don't do something like that as well. So I don't know, man. It's going to be interesting. I think this one's going to be a little fiery, but I do think that they're going to stay within the bounds and the realms of the judge's rules here. Bluebird 711, she said, what up? $3, $3.99, $4 holler coming through here. And you know what? They get you right back on here with another opportunity to be in the winner's circle. You know, the wins are always flowing through here at Buzz Nation. I love that. Thank you so much. Boom. Boom. We've already got 4 on the new wheel. That's how that works. Quick ski.
In your questioning or statements or comments between questions and nature of that. And so that would also go with the term murder, I think, to the extent that it reaches a conclusion that the defendant
Oh my God! Yeah,
committed
that mouth
murder,
noise is a little intense, isn't it? Is that Hitler?
prior to the closing. Now, certainly the allegation that the defendant committed
Is there
murder
a
is
piece of candy
going to
rolling
be,
around in here?
relevant
Or is
and
that just
probably
dryness?
appropriate in opening statements, perhaps even in voir dire. But apart from that, if you're intending to
Isn't
go
it
there, you need to bring that to my attention outside the presence of the jury. And that's obviously important. Both of those are important to make sure your witnesses
Yeah.
understand as well. With respect to inflammatory evidence, I don't know what that is until I see it. Certainly there are rules regarding prosecutorial misconduct. I think counsel is likely well-versed in what those rules are. I'm not one that says I'm going to order that you follow the rules. You are counsel licensed professionally by the bar, admitted to this court. Your obligation is to follow the rules. And that is what I expect of counsel. And so any
He's laying it
attempts
in.
to skirt the rules
Carla, $2.
a good faith
The
basis
best group
to do
of people.
so
Hell
will
yeah!
be
Thank you, Carla.
problematic.
Appreciate that.
In terms of, and I think really where
Got you right here on
there's
that
some
thing.
potential
$2.
bristle
Thank you
meat
so much.
on the
Appreciate
bone
it.
here,
That's
I
number
should say,
5 on the wheel ski.
relates to,
Shit.
I suppose, the photographs or videos of the decedents and
That's
the
amazing.
state of the crime scene. I
Oh,
would
it's a
imagine,
G-
from
G-ing it
what
up
I've seen,
around
some
here.
of those photographs are particularly graphic, but make no mistake, these murders, whoever committed them, were brutal and were horrific. And so I suspect that the evidence will reflect that. Now, if it comes to cumulative evidence, or perhaps some that are unnecessarily graphic, we can address that on a case-by-case basis. And so I think the idea is before you show the evidence to the jury of that nature, that counsel be given a copy of that. Obviously, if you're going to be seeking to introduce those, they will be given a copy, and we can have a discussion outside the presence of the jury about how many, which, et cetera, will be presented. But I don't feel it's really does anything it doesn't advance the ball.
Jay
for
Money
me
said,
to
"Let's go again."
abstractly say,
$3,
don't
Willie, baby.
use, inflammatory evidence.
Thank you, Jay. That's 2
So I'm
chances
not
on this
going to
wheel.
do that.
Good
I
luck.
will,
Number
rely
6,
upon the
halfway through
obligations
another
of
wheel.
counsel as professionals to understand their responsibilities. And when it comes to the specific actual evidence, then we can review that before it's presented to the jury. All right. Next is unnoticed 404B evidence and evidence regarding the 404B evidence that was noticed in this case, which is
What's
the
up, Tina?
traffic stop.
Been having a good
I'm
show here
prepared to
tonight.
address that, Your Honor. I do note on the court's list, the state's motion regarding improper death penalty comments is actually next in order, but we'll take it in whatever order the court
Well,
prefers.
let me, if you want to address that, let's do that first. I apologize. I should have included that within the group because I think it kind of falls within the same category. And I think you understand what my rulings are, but I can address it specifically if council would like me to.
Ms. James was going to handle that. We're happy to just submit it to the
I think
court
it's
on
the
the
defendant's
files.
motion, so if they want to argue it, they can.
Your Honor, it's the state's motion.
Oh, is it the state's
It is the
motion?
state's motion.
I apologize. Oh, that's right. I was thinking of it in the opposite terms. That's fine. This, if you want to,
I mean, that's the only way
Ms.
to
Jennings
really think
addressed that
about it,
briefly,
in the
you may.
opposite terms when you're wrong. I'm going to start using that. Anytime I'm wrong, oh, I'm sorry, I was thinking about that in the opposite terms.
Your Honor, I will.
and this relates to the concerns that the defense may say something like the state's trying to kill Mr. Kohberger or something of that nature, as I understand.
Yes, Your Honor. There has been a history in this case of that mischaracterization of 18-4004A. We're just hoping that that mischaracterization is not made in front of a jury. But considering the court's comments this morning, as well as defense counsel's comments, that there shouldn't be statements made whose sole purpose is only for an emotional appeal, I think that this is settled. And defendant replied basically saying the same in their response, that they suggest he use phrases that comport with existing language and statute and jury instructions, and that's what the state is asking for. Thank you.
Any response?
Briefly, Your Honor, we're satisfied using language that's already spelled out by statute, by jury instruction, and that sort of thing.
So with respect to this motion, I think the ruling is really sort of encompassed within my, for lack of better term, ruling or instructions about argumentative comments or statements of counsel. The example spelled out by the state, I think, would fall within that category of being argumentative and would be improper by counsel. And so obviously that shouldn't be done. And so they should comport with the language and at the appropriate time and in the appropriate way that is not argumentative to address that issue. And so they are so ordered. All right, let's take up 404.
Good morning, Your Honor.
That's all.
Your Honor, as it relates to the unnoticed 404B evidence, I understand what's been the discussion on similar verbiage and concerns earlier. However, one of the things that I think it's important to note about this is that although the state has agreed that they will comply with the rule, what we do have so far in self-authenticating records, it's our position is already two mislabels of the evidence. And the specific examples are that technically the DeSales paper, the way that the state wants to use that, would fall under 404B as other act evidence. It's a 2020.
It's a bad act?
It's the rule says other acts to show knowledge or plan, and so the state has expressed that they plan to use
how you
that
can use
paper.
it. It's.
I'm sorry, I can't hear you.
That's how you can use it under 404. The way you can't use it is a prior term of colloquial term is a prior bad act to show that the party acted in conformity with that they have propensity to commit bad acts. For example, as it relates to the traffic stop.
I bet
I
Ed
suppose
Taylor
the
dreams
concern
about
is-
Judge.
Well,
She's probably
he
like,
committed
why?
a
Why
bad
do we
act
do
of
that?
not wearing a seatbelt or following too closely, and therefore he's likely to commit murder. I mean, that's how the rule works. I'm confused about your statement about the prior academic paper, how that would possibly fall within 404.
Well, when in the self-authenticating pleading that the state filed about the DeSales document, they indicated that that shows that he has knowledge of cleaning up a crime scene. So our position is that we
yeah.
don't want to make
Yeah,
sure
it
that
would.
there's not
Tammy,
some
now
sort
you're on
of
something there.
in-run. The
do
same
that one soon.
example that I will give you has to do with
Help me
the
understand.
Amazon
I
records.
don't think that we're reading the rule the same, is the concern I have. And so I want to make sure I understand your position. Because what you're saying is the state's trying to use evidence to show the defendant had knowledge of how to sanitize a crime scene effectively. And that's one way that you can use evidence of a prior bad act that might otherwise be concerning in terms of propensity evidence. 404B doesn't exclude evidence of plan, knowledge, intent, et cetera, that's not anchored to a bad act. And so I don't see how 404 relates at all to the DeSales paper.
Well, it's our position that the way that the state is putting this in is, in essence, trying to anchor it to a bad act without giving notice of that.
Well, I just don't think your understanding of the rules comports with my understanding of the rule.
All right, well, I appreciate that we have a misunderstanding of the rule. Nonetheless, that's my position. And another example of that is the Amazon records, where they're claiming that those are self-authenticating relating to purchases. And that also has not been noticed.
But it's not a bad act to purchase things on Amazon.
But the state is using it, Judge, to show, using it as other things to show a plan or knowledge or intent.
But that is not what 404 precludes.
Yeah, like, I don't know the law that fucking well.
4 precludes a bad act, a prior criminal act, a prior,
Yo, Greenie.
but the best term is bad, something that would suggest that it is in your character to commit a bad act, to commit the crime because you've committed another bad act, right? You abused your significant other on one occasion, and therefore you have a propensity to abuse a significant other on a later occasion. That's 404B. Evidence that somebody has knowledge or has a plan not anchored to a prior bad act isn't covered by 404. It's not precluded by 404.
It's our position that the state is trying to do an in-run on that with this evidence. And that's why we raised the issue of 404B, anything that's unnoticed, not coming in as a bad act. One of the ways that we contemplated drafting this motion was because there were simultaneous filings of motions in limine, was to come up with a list of things that we were concerned they may call prior bad acts. But because we didn't know what they would raise, we raised it in this form, which is without notice, they should not be able to argue evidence is a prior bad act or make any attempt at an in-run on that rule.
So I'm not understanding what you mean by an in-run on that rule in this context.
By saying that the argument about the Amazon purchase is that that was prior to November 13th,
Right.
2022, for the purpose of making a plan. And that's the argument that the state will make about that.
I think I understand what you're saying. I just think we're
So I think,
completely missing
okay.
each other's understanding of the rules of evidence.
Well, I still stand by my position that the state should not be able to in-run that, and I'm hearing the state say that they have no intention
You can't even
of
give a
doing that.
definition of what in-run means in this context.
Well, I'll hear
Keep saying the words.
what they intend to do in terms, because I think that your reading of the rule puts requirements on them that doesn't exist under the rules of evidence, but I will listen to their
Okay.
response.
Do you want me to go to the 404B on the video or keep it
On the
separate?
video of the traffic stop.
Okay. First of all, there's a pleading that was submitted to the court yet yesterday, and I have 3 copies of the video marked as Defendant's Exhibit D1 that I'll provide to the court for your review at your convenience. One for the court, one for you, one for Ms. McLaughlin. It occurred to me that it would be much easier for you to determine what you thought about this video if you actually got to see it in full. We don't need to play it in court. You can review that at your convenience. It's not our position that the traffic stop equates to a crime that makes someone capable of murder. It's our position that the traffic stop video brings in other acts that the state is trying to end run on. And I want to give you examples. In this video, things that make it more prejudicial than probative are that it provides presence in Moscow. It is at night. It is a visual of the car that is not just the make and model. It is Mr. Kohberger's statement that he doesn't think seat belts provide much in the way of safety. Mr. Kohberger's question about why they need his phone number. Mr. Kohberger's question about how the officer reacts when people lie to him about wearing a seatbelt. If the court allows this evidence in, the state has the ability to use this to make many other points beyond identity. And the jury would have the ability to potentially seek to ask to rewatch the video and draw other conclusions that we are worried about, such as I mentioned, him being at night, not wanting to, it being at night, him not wanting to give his phone number, which could be construed as he wants to hide his identity.
Date of this traffic stop?
Pardon?
Remind me of the date of the traffic stop.
It is on August 21st. So it's
What year?
of 2022. Okay. So it's remote. It's
before the murders.
Yeah. Yes. Before. It's clear video of the car as opposed to the videos that are used at 1122 King Road.
Why is that a problem?
Because I think that the state, again, can use this video as an example of where you can see a white sedan clearer than you can see it on 1122 King Road in those videos.
Why is that a problem?
Because there's an argument, the argument could be made that the cars look similar.
Isn't that the whole point of it?
Exactly, and so it's different.
The point of it being, as I understand it, is to show that the defendant owned a white, well, I can't remember the name, the make.
Hyundai
Elantra, and that he, as opposed to others, drove that vehicle.
Correct, Judge. And so when this video comes in, it's much more than a witness saying, you know, I looked at registration records and registration indicated that he owned a Hyundai Elantra. When you see it on a video, and then there's going to be other videos that are put into evidence, there's a different argument to be made as opposed to someone verbally reporting a make and model. The state
Sounds like that makes the evidence of, I guess I'm just not tracking again under 404 how that particular issue. Now, there may be the ability to cross-examine the FBI specialists about, well, this video is grainy, how can you make this determination of what the automobile is, et cetera, to me is different than, okay, that's what their conclusion is, which you can attack. The evidence that he has a white Elantra within the years and that he drives it, it's prejudicial in the sense that it doesn't help your case, but I don't see how it's unfairly prejudicial, which is kind of what you were talking about, which is 403. I haven't heard anything that's 404, but...
Okay, well, they've noticed it as 404B evidence, so I'm arguing it in that context and what other things can be drawn from this video that make it overly prejudicial. The other thing is that the state's expert disclosure by Special Agent Nick Balance lists August 21st as one of the dates that they claim that Mr. Kohberger is near the 1122 King Road residence. And so the date of this traffic stop is relevant to the state for that, their ability to argue that. That also makes it overly prejudicial.
It makes it relevant. It doesn't make it necessarily overly prejudicial.
Judge, the combination of these things is that this video has the ability to be much more than what the state is claiming. The state is claiming that it proves who he is, what his phone number is, and the type of car that he was driving. And it's our position that when you watch the video, there are other arguments to be made that make it more prejudicial and therefore excluded when there are a myriad of other ways that the state can prove his identity,
You don't get
his
to,
phone
and I don't
number.
get to tell the state how to try their case unless they're violating the rules of evidence.
Of course, I don't get to tell the state how to try their case, but I do get to tell this court what our position is regarding that evidence, and when we think that evidence is overly prejudicial and can be construed to do things that the state is otherwise saying the evidence is meant to do. And that's the point of this argument. We ask that you exclude this video, which I will ask that it be, that the marshal provide that to you, and that the state use a different method of proving identity.
Thank you.
I think after what we just heard, we can cut to the chase. The defendant doesn't seem to understand what the balancing test under Rule 403 is. There's no question that the video with the evidence, the defendant's admission of his identity, with his admission and the evidence showing it was his car, the description of the car, the registration of the car, his address, his telephone number, that's all incriminating evidence. That's why the state is offering it. The defendant doesn't like the fact that it's incriminating, but that's not a basis to exclude it. Under Rule 403, in order to exclude relevant evidence such as that, the defendant has to be able to demonstrate to the court's satisfaction that the relevance evidence, that its probative value is substantially outweighed by a danger of unfair prejudice, confusing issues, misleading the jury, undue delay, wasting time, or needlessly presenting cumulative evidence. Just because it's prejudicial, and just because the defendant doesn't like the fact that we can prove who he is, that we can prove what car he's driving, that we can prove what his phone number is, that we can prove his address. I mean, those are all things that tie together to connect the defendant to the homicides. Just because they don't like that isn't a basis to object to it. And so, Your Honor, we would ask that the court deny the defendant's objection to the admission of this evidence.
What about the concern within the video, as I understand it?
These are
First, you have what is a 404 issue, which is a prior bad act, though one I'm sure everybody probably in this courtroom has committed at one time or another.
Whoa!
Of
Speak for yourself,
violating
motherfucker.
the traffic laws
Shit.
In some way, including by not wearing a seatbelt.
Whoa! Record's clean, homie.
And so, can you
I do have some
address
stuff, but you know what?
that part of it, the prior bad act, and how the court should deal with that? And then also, I am concerned with the issue raised about the communication between the officer and Mr. Kohberger. For example, his asking why they need his phone number. That could, I think, be unfairly looked at as if he has something to hide, which would be, I think, unfair. And so I am concerned about that.
And I appreciate Your Honor's comment. And I think when you review the video, you can put it, the court will be able to put it better into context. The state certainly doesn't intend to argue or suggest that the colloquy or the discussion between Mr. Kohberger and Deputy Duke somehow showed that Mr. Kohberger was a bad criminal type of person We certainly are not suggesting by any stretch of the imagination, although the defendant alleges it in their response to the state's filing, that the fact that the defendant was apparently speeding without wearing a seatbelt somehow means that he is guilty of murder. I mean, that's a preposterous concept. And the defendant seems to have backpedaled from that before Your Honor just a little bit ago. The state's purpose is to elicit the vehicle and connect the defendant to the vehicle, the description of the vehicle, the defendant's name, of course, his phone number, his address. That's what the state's interest is. And the state, as it views the entirety of the relatively brief traffic encounter, we don't see anything incriminating or making the defendant a bad person out of that. Now, of course, Your Honor will need to see that and decide if its view is different. But we don't see that as being prejudicial. We certainly are not trying to argue some sort of propensity that because he questioned about, why do I need to give you my driver's license, that all of a sudden that makes him a murderer. I mean, that's beyond a stretch of imagination. Does that answer Your Honor's question?
Thank you.
Thank you, Judge.
Response?
Judge, there is a way to, clean this up with regard to this, and that would be to not allow the jury to see the video, to have the officer who made the stop, testify about the stop, testify about the identification, the make and model of the car, and the phone number. The argument that the defense doesn't like troubling evidence could be said about every single thing that the state wants to proffer in this case. This is a highly circumstantial case, and so every little fact that is circumstantial is going to be relied upon by the state. And so we have to look at a critical eye with everything that's coming in before this jury to see what the cumulative effect is going to be of that. And so it's not that we don't understand that his identity is going to be proven. As I argued, there are a myriad of ways for them to bring in his identity, but to add all the other components that you will see in the video do much more than just prove that he's Bryan Kohberger with a phone number in a Hyundai Elantra. Thank you.
All right, with regard to this motion and the 404 issue in general, the standard for the admission of evidence that falls under 404 is that the court determined that there is a factual basis by which a jury could find more probable than not that the prior act, if you will, occurred, that the prior act is relevant for a purpose other than propensity, such as identity, and that a balancing test under Rule 403 would not otherwise preclude the evidence, i.e. that the unfair prejudice does not substantially outweigh the relevance. When it comes to 404B evidence, and that's how this was noticed and brought to the court's attention, which is the framework that I'm looking at, 404B does not apply to just any prior act. It applies to prior bad acts, other crimes, other wrongs, not other acts of benevolent or
Bluebird built the freak out of y'all.
Of a type that doesn't implicate propensity. And so I don't see the concerns that were outlined by the defense, for example, related to the DeSales paper and things like that, that's a 404 analysis. That's simply a 403 analysis, which is there unfair prejudice or other concerns that substantially outweigh the relevance? And there isn't the same notice requirement for that issue as there is for 404B. And so I don't see this as the example is raised as a quote-unquote end around at all. And so the state does have a notice obligation when it does come to prior bad acts that it may seek to introduce. At this point, they've only identified the one, which is the traffic stop. The Rule 404 requires notice in advance or during trial when the state is aware of the need for it. And so, I don't think we can say that the shot clock has run out on that at this point. But certainly, as soon as the state is aware of the likelihood of the need for that, they have that obligation to seek that. And at some point, the prejudice to the defendant in terms of lack of notice will upend the state's ability to use it if not properly noticed. And so as a general matter, the state is required to provide that reasonable notice set forth in 404B. With regard to the traffic stop, the concerns identified by the defense related to, well, let me go through the 404B analysis. It is technically a prior bad act, which is the sort of colloquial terms used by the courts in describing 404B evidence, in that the defendant was stopped for violating traffic laws and ordinances. I think there obviously is evidence by which a jury could conclude that that conduct occurred. The next question is it relevant for a purpose other than that he has a propensity to violate the laws? I think in this case there
Question the
clearly
law,
is
right?
a other purpose besides that,
He's running that mouth
which
in that
is
stop.
identity, which is ownership of the automobile.
I want to show that he
is alleged to be a suspect automobile.
is not autistic
and
or
control
whatever.
over that
If
automobile.
he's going to start acting kind of like weird in the trial.
And so I think there is a valid purpose for it. And the next question is
Shifty
that
eyes.
relevance substantially outweighed
Like,
by
well, they didn't
other
have shifty
prejudice.
eyes this day.
The fact that it is more powerful evidence than perhaps a simple description by somebody of DMV records doesn't make the
I don't know,
evidence
he was pretty
unfairly
weird in that.
prejudicial. It just makes it more effective.
I only watched it once,
and
but I
that
do
is
remember
not the
like
type of
questioning, I
unfair
guess,
prejudice
while they pulled him
that the
over,
rule
right? And he was saying like where he's from,
contemplates,
it's
and I
you don't have to do it, maybe something
frankly
like
track
that. The law's
the
different
defense's
with
argument
the.
with respect
I don't
to
know.
that. And so
I need to rewatch
I
some of the
think
old stuff.
as a
It's
general
good.
matter, the traffic stop
But
is
he is, I
relevant.
got you.
I think there is zero danger that the jury will conclude that because he didn't wear a seatbelt or sped, that he therefore has a propensity to commit murder. I just can't imagine any reasonable person coming to such a conclusion. And certainly the jury will be instructed that they may not use that evidence as propensity, may only use it for the relevance of things like identity, ownership, and control. There are concerns that were raised, however, and so while as a concept, I think the video is appropriate under 404, or notwithstanding 404B and 403, I do want the video potentially, I'll look at it, and it may change my mind, but just from the description, I am concerned about some of the interactions with the officer, about
Kipler's concerned about
that
it
was
as well,
mentioned
though. I
that,
mean,
that Mr. Kohberger
They might get
questioned
that
why
video
the
out of
police
there.
needed his phone number. That the officer said something about
It will
how
be
he
edited.
views people that don't wear seatbelts. I don't think any of that is relevant, and it does potentially create some unfair, some danger of unfair or unnecessary prejudice. So I think it needs to be redacted to exclude those kinds of things and have the video that shows his vehicle, that he gives the registration, that identifies it as his, that his answer to what, not the stuff leading up to what his telephone number is, but if he gives the telephone number, the answer, what the telephone number is. I think that's what we ought to see and probably not much else. So I'd like to see that before it's played to the jury, and you can work on redacting that and showing it to counsel, and within the confines of my rulings, they can raise any concerns they have.
Thank you, Judge.
All right, let's talk about who is going to be in the courtroom amongst the victims and the defendant's family.
Family stuff. Yeah, we may keep doing this. We got an hour into it. Yeah, if you guys want to keep doing some of this Kohberger stuff, I'm down. There's a hell of a lot of it here to go through, so maybe start sprinkling in some of this through some of the evenings here. Yeah. I'm definitely going to be watching the trial, though. I don't know if, it would be cool if I could do the entire trial. I guess we'll see. Maybe I could do it at night, and it would take a while. I don't know. We'll see. We'll see how it plays out. Because, that's the trial. That's the one that I've been, following since the beginning of this channel even, so. Yeah, Bluebird. Yeah, thanks for coming in here. Sometimes it does get into a weird little statickiness, and that happens. And I have a little fajita. It looks like fajitas. It is fajitas. Boom, right here. Pop that up on the screen, and it alerts me to fix the sound. So, and thank you for the thumbs as well. Boom. Dude, Greeny. Yeah, thank you. Appreciate it. Dude, yeah, I have a rough time. We were talking about that earlier on X. I used to be in a lot of streams. Mainly I really just hung out with Jay. I like hanging out with Jay, which, everybody, majority of these folks love Jay as well. But yeah, I can't really, I'm good on a lot of chats, but we have a really cool group here. I think everyone kind of bounces off of all of our personalities mesh well. It's good stuff. It's cool. Super chill is what it is. Try not to get, it's very serious, the stuff that we cover, but we try not to take it too serious while we chat about it. But sometimes that's inevitable because it is. We're usually chatting about fucking murder, which is insane. But yeah, I'm going to be keeping up with it regardless, so might as well start, getting ready. We're within, 4 months now? It's getting in there. We got a quarter of a year left until the Bryan Kohberger trial, unless something crazy happens. I know. He'll stream every once in a while. I still don't get to see those because it's at time periods when I'm not really, it's like at night, usually, or in the evenings, and yeah, I'm usually doing something, with Cassie or with Gypsy, getting something going, doing some dinner plans, something along those lines before shows, so only so much time in the day. That's what they say. But yeah, tomorrow night, you do not want to. I'm talking to her right now. She's riled up. She's celebrating. She has some good news today. Jessica for Justice. She's going to be coming through here tomorrow night, 9 p.m. Eastern time, as we're going to be starting the show. We'll probably be hanging out till about midnight or something. That's about the norm. Usually about a pretty good hang sesh. Yeah, and then you're not going to want to miss the following week. It's going to be a Saturday show. It will probably still be a Feral Friday as well, but 4/19, there's going to be a pre-420 show. That's a Saturday night. Jay is coming on here. I think I got Dandy Savage on that one. It's going to be very good. It's going to be very fun. But yeah, I've got some stuff planned out. Other than that, I need to start trying to get some more guests on here. I'll probably try to get another Bob show eventually. And probably bring some. Lauren Conlon, I'd like to get Lauren on here regardless. She's all in everything, dude. She was at the Harvey Weinstein freaking trial, interviewing his attorney. Man, incredible. Incredible the connections that we have at our fingertips here within the Buzz Nation. It's crazy, quite frankly. So it blows my mind when I really think about it. Yeah, tomorrow night, do not hesitate to click on the show. We're going to be, I'm not even sure yet, but it probably will be a legit horror movie. We don't watch we watch horror. Usually watch horror comedies, something that's a little lighter. I think we've watched a Friday the 13th. We've definitely watched some legit horror films before, but tomorrow, Jessica likes some legit horror. I don't even usually go down these roads a lot of times now. I usually like to go down the retros. Still love some old movies I've watched 1,000 times, or horror comedy. The types of films that Evil Tunes is amazing, right? That's not a legit horror movie. It is, but it's something horror related. I'll tell you that. It's going to be funny. Yeah, 4/19 is that show. It's a Saturday. But I'm sure there will still be a Feral Friday, I'd imagine, as well. So I'll be hyping it up then also. But yeah, Jay is coming back, making the return to the Publicly Buzz Live. Dude, it's freaking crazy good, dude. It's crazy. Oh my God, yeah. This is going to be, we're talking about a possession film right now. That's what we're talking about. So I'm not going to give away the name just yet. You're going to have to come through. That's the tease. You're going to have to come through. Yeah, oh, yeah. Gotta come through. That's what I said. Gotta come through. Come through. That's what I said. Baby, 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 baby. Yeah. You gotta come through. You gotta come through. You gotta come through. Gotta come through. Yeah, you gotta come through. Phil, Friday, what we do? Gonna watch a real movie, real whore. Gonna watch a real movie, real whore. What's it gonna be about? Probably possession. Yeah, probably possession. Yeah, Jessica for Justice. Gonna roll through. Yeah, coming through the house of the Buzz Nation. Yep. All right, everybody. I'm getting the hell out of here. I've been singing, I've been dancing, I've been going. Everybody's getting hyped up. Look at this. Everybody's ready. A legit horror movie. Feral Friday. Don't miss it. Have a great rest of your evening. Have a great Friday before Feral Friday. And yeah, let's kick this week's ass. Love you. Boom.
Pittsburgh.